And then we calculated, we sat on the Supreme Court site, how long has been this time span? Justice Jagannath Reddy became and was appointed a Supreme Court judge on 1st of August 1969. And Justice Sudarshan Reddy retired on 7th of July 2011. A span of about 41 years and 11 months. And only for a period of about 11 years and 7 months in the history of the Supreme Court, there has not been a Reddy on the Supreme Court bench. So you can see the contribution they have made. In fact, a friend of mine who was himself a Reddy said, Reddys are ever ready to serve in the Supreme Court. It was always a pleasure to appear before Justice Venkataraman Reddy in the Supreme Court because he was always urbane, patient and polite and treated all members of the bar with great civility. His judgment on the Parliament Attack case is worth reading. It runs into 300 pages and it has been meticulously crafted with precision in a case with very, very great complexity. I see Jethamalani here, who got an acquittal, notwithstanding a conviction by the trial court, both in the High Court and in the Supreme Court, in spite of all the prejudice against the accused. Friends, before I conclude, let me congratulate Prashant Kumar and his team for the very contemporary and very interesting subjects which he has chosen, and more importantly, the type of speakers and chairpersons who have been assembled, and see the names in the program. Soli Sorabjee, Jethamalani, Ashok Desai, K.N. Bhat, P.P. Rao, Shanti Bhushan is going to chair a session, and so many other distinguished speakers, R.K.P. Shankarda, who is an authority on commercial law and on various other topics. Now, in a convention, to have such a star-studded team of distinguished lawyers, I think is unique in the history of this country and the Bar Association of India. I think we must thank the Prashant Kumar and his entire team of secretaries and other office bearers. Before I conclude, I want to cite what was said by our President, the first President of the Bar Association of India, and I think this has been circulated earlier, Mr. M.C. Settleworth, who was the first Attorney General right from 1950 to about 1962. And this is what he said on 2nd of April 1960 at the formal inauguration of the Bar Association of India in the presence of Jawaharlal Nehru, President Rajendra Prasad and Justice Sinha, who was then the Chief Justice. And this is what Settleworth said. And this is what has inspired us not only to have this convention, but if possible, have rule of law conventions over either annually or biannually. And I quote what Settleworth said. We aim at upholding the Constitution of India, the representative, free and democratic form of government established by it, and the promotion of the rule of law. We are to endeavor to apply our knowledge and experience in the field of law to the promotion of public good. And comes a significant sentence. The men of the law cannot afford to stand aside when the country is forging ahead along its newly chosen path. We should not stand aside, we should participate, and whatever little efforts we can make to uphold the rule of law. And he concludes, it should be the paramount duty of a body composed of men pledged to the smooth and impartial administration of justice and the orderly development of true democracy to earnestly ponder over these and like situations and take active and energetic measures to counter them insofar as such action may lie within its power and uphold the rule of law. I think more significantly, the Hony Palkiwala, in his book, We the Nation, selected as, before even the preface, some words which were quoted by Satchidananda Sinha, who was the provisional chairman of the Constituent Assembly. And Satchidananda Sinha cited what Joseph Story, the famous American jurist and judge, said. And these are the words which were quoted by our provisional chairman at the inaugural session of the Constituent Assembly. And these are the words of Story, and I quote, "The Constitution has been reared for immortality. If the work of a man may justly aspire to such a title, it may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers, the people. The keepers of all our liberties are ourselves, the people. And unless we are active and unless we are energetic, the rule of law is under great stress. And I think the topics which we have chosen, each one will give his views on these very important controversies which are going on today. Controversies relating to, say, the last one is between the army and the civilian, corruption, black money, electoral reforms, all these subjects which we have selected. Friends, I once again thank members of the audience and our distinguished guests today and the various speakers for coming here and taking the trouble from coming in spite of 3 or 4 holidays which you could have otherwise enjoyed. Thank you very much, and I thank you very much for attending.
Divan, there is an inimitable Anil Divan stamp on every aspect of this program. And all of those who know him can read it between the lines. Now friends, another thing which I wish to say is that this convention we wish to organize every year, but like you know, even in a game of cricket, the classical cover drives and others are no longer, they are enough to pull the audience in. So we will try to combine the substantive topics with also a kind of a social program in future in which lawyers with their families can come, deliberate, and also have a time where they can mingle in a relaxed atmosphere with their colleagues from all over the country. And I think that I will get all the support from the members of the bar in that endeavor. So next time we may take this convention to Goa or some other place, as will be decided by our committee. Now, I am too small a person to speak about Justice Verma. Our president has already had a very long and fruitful association with him, especially as an amicus curiae in the Jain Hawala case. But as a student, I must tell you, I was always mystified by a concept of Irish poetry when I was studying literature that was called Anima Mundi, which is a sum of racial memory that animates the entire race. Now, if we talk about our present day rule of law memory, the way the deep reserves of our cultural and legal instincts speak to us to act in certain way, I think it is people like Justice J.S. Verma, not only during their tenure as the Chief Justice and a judge at the highest court, but throughout, after demitting the office, being the source of deepest reserves of our national conscience in grappling with all the issues which stare us in the face, and his guidance has been always there to lead the country to a saner path. I will now request Justice J. Verma to give his address as the chief guest. Thank you.
President of the Bar Association, Mr. Anil Divan, Mr. Yakesh as he is widely known, Justice P.V. Reddy, Shri K.N. Bhat, Shri Prashant Kumar, Shri Yakesh Anand, and all the distinguished members of the legal fraternity, ladies and gentlemen. Let me first of all thank you for inviting me and giving me this opportunity to be with you on this momentous occasion and to share some of my thoughts, also my deep ambition, many of the issues. And I also thank you for considering me relevant even more than 14 years after I have left the court. My concern for the institution, naturally, not merely as a citizen, but because of having been in an institution which gave me everything, is bound to be there till the last day of my life. And therefore, I am really fascinated by the theme which you have chosen, which, to my mind, not merely poses the question, but also indicates the answer. I would like to begin from where Anil ended, because what he read out from Sachidanand Sinha's speech as the prominent speaker, quoting Joseph's story. Actually, if some of you may recall, I have quoted it in one of my judgments, as also what Dr. Rajan Prasad said. The constitution, like a machine, will ultimately depend on the men who work it, because the worth and efficiency of a machine depends on the worth and efficiency of the machine man. Now, rule of law in crisis, of course it is in crisis, all of us know it. Need for radical reforms. We have to first therefore pose this question: who are those who are responsible for ensuring the implementation and preservation of the rule of law? I think the answer is obvious. In our constitutional scheme, the greatest responsibility is of the judiciary. And when I talk of judiciary, I don't mean merely the judges, because we all come from the bar. That includes both the bar and the bench. And therefore, if there is a crisis and needing reform, I think we have to start with ourselves and see where we have gone wrong. Now let me first mention some of those factors which come uppermost in my mind, which have led to this situation. Now, frankly speaking, I felt very demeaned and insulted when I found everyone talking that a law is needed with legal sanction to regulate our action. Because what I thought was that the framers of the Constitution, in the scheme for the judiciary which they provided in the Constitution, didn't think that it was necessary to provide such a mechanism to control the High Court and Supreme Court judges, except in an extreme case where they need to be removed for proved misconduct, for which also a law has to be required to be made by the Parliament. So they wanted deeper reflection even in the making of that law. And it was only in 1968 that the situation arose for the first time that the Judges Inquiry Act was enacted, for a different reason, you see, than the one which we are faced with now. For the subordinate judiciary, control was provided in Article 235 not in anyone else, but in the higher judiciary itself. Why? Because it was thought that the higher judiciary, by practice of what is required from the judges, will instill that kind of culture and, if need be, control the subordinate judiciary. Now there is a clamor for law to be made, and of course a partly successful attempt in which I was a party was made in 1997 when I was in office, of self-regulation, because I thought that's the next best thing to do. The only redeeming feature I find is that the restatement of values, it appears, is going to form a part of the statute. But the kind of talk which I heard during the debates in the parliament, I mean the manner in which people talk, you see, about the higher judiciary was indeed very insulting. And every time I heard that, well, I felt, I may not be there, but it's for me also. And why not? Because when I heard that debate, or rather the defense of Justice Samarth Sen in the Rajya Sabha, his argument, if I understood it correctly, was that if it was a misconduct, it was conducted as a lawyer. The judge has got nothing to do with it. Well, I thought you can't be a Dr. Jekyll and Mr. Hyde. You can't be a corrupt lawyer and then be a very honest judge. I mean, now, you see, and that was with great vehemence. Now, if this situation arises, then naturally others are going to step in. So, you see, the mere fact that we have brought about this situation is something to think seriously about. Well, I think the leaders of the bar have also a very important role to see that we judges don't go off the track. You see, but then, that is, I hope the seniors will forgive me for being a little too outspoken, rather verging on being harsh, but they are quite used to it, of course. They don't hear from me those things very often now. Well, I would expect you to walk up to any one of them whom you find not doing the right thing in the chamber and tell him this is just not done. Now today it has come to this. When we talk of the top man in the executive, everyone sings a praise for his honesty. Well, I thought that was something which has to be assumed with everyone in any position of authority. I was reminded, or rather I'm constantly reminded of one incident of 1985, when I was Chief Justice of Madhya Pradesh, and we were considering additional district judges for promotion, for appointment as district judges. At that time, you see, that was a promotion post. There was one gentleman, I won't name him because maybe someone here knows him, an additional district judge, a fine human being, but that's all what you could say about him. You see, it was only by the Peter's principle that he had risen from the post of civil judge to additional district judge, because invariably any appeal brought against his order, the lawyer would stand up and say, my lord, there is an appeal from the judgment of so-and-so. Judge would say admit, because even if the conclusion was right, the reasons had to be wrong, they had to be corrected. So naturally everyone thought in the full court that he has had enough and there's no occasion to appoint him a district judge. Then one of my colleagues, Justice Malik, he turned to me, he said, Chief, why not make him his honest? I turned to Malik, I said, do you realize the implication of your statement? I said, we'll have a district judge just because he's honest, he has to be honest. Now from that, in 1985, forgive me for saying so, with all due respect, I mean, I don't mean any offense, and he's a first-class judge, and I was very upset when I heard a Chief Justice soon after taking oath say in the Rashtrapati Bhavan, my only asset is my integrity. And the other thing which I heard was that the PILs, public interest litigation, needs to be controlled. Of course, all of us try to control. You see, PILs which were misconceived, which were frivolous, which were set up as shadow boxing. But you don't throw the baby with the bathwater. You see, if the constitutional philosophy to which we are all sworn is distributive justice, and the vision of free India is what Rajendra Prashad said, which is encapsulated in the Directive Principles of State Policy. Then after all, you see, you can't label PILs as a class, as something which is wastage of course time. I thought a matter which influences the lives of a large number of common people is far more than what may be of concern to only a few. Now this is where, you see, I think the leaders of the bar matter, because, you see, well, credit must be given to members of the bar, which I have always said, for coming forward. You see, in all public interest litigation, and my experience was when I was there, no lawyer who appeared as an amicus curiae, including the junior ones, not only the senior, they would not take even the expenses incurred by them, even though they would charge fabulous fees. Of course, I said, fine, you charge fabulous fees from those who can afford to pay. But then, you see, so this, and all what the court has been done, for which praise has been showered on the court, would just not have been possible but for this active cooperation of the bar. And my own, if you ask me, my biggest satisfaction is, I saw during that phase in the court, the bar come forward to help us do so many things which would have just not been possible if the bar had not cooperated. Now that spirit of the bar needs to be reflected, I think, throughout. If you ask for, you see, for me to identify one radical reform which is needed, I think the purpose for which the judiciary, which includes the bar, the purpose for which the Constitution made us the custodians of the rule of law and responsible for ensuring its preservation. If we ensure that, I think automatically everything would be done. Today also, when there is a crisis, when the politicians are talking all kinds of things against the judiciary, when people's faith ultimately is they want to come to the judiciary. But then it should not satisfy us that we are less talented than the others. I mean, let them come to us because they think the best of us, and not because they think the worst of the others before whom they don't want to go. So, see, I'm reminded of one thing which I have said very often, and I think many lawyers Mr. Reddy. The first book which my senior GP Singh, which all of you are very familiar with, I mean, one of the greatest judges like Learned Hand, who should have come to Supreme Court much before any one of us, and didn't come. You see, the day he first took notice of me, I went to him as a stranger. For a month, he didn't even look at me because he wanted to see how serious I was. The day he took notice of me, he got up from his chair, picked up a book from his library, gave it to me. He said, look here, you will read all the law yourself, others will tell you, this no one will tell you, better read it first, cover to cover. And that was the collection of lectures by a senior member of the Madras Bar, K.V. Krishnaswamy, on professional conduct and ethics, to which the foreword was written by Sir Maurice Guy. Well, that was the 1947 edition, and I haven't seen any edition, even reprint thereof. So I had one copy, and I tried to get a photostat made, and I've given to many. I don't have anyone now. Now I think we need to go back to that. And the foreword of Sir Maurice Guy, I think that if all of us remember that on both sides of the bar, well, that alone will take care of all the crises. He said every member of the bar must remember that he not only belongs to a noble profession, but You see, he holds that position in trust for the entire